Presentation title: Liability of Administration in Contract and Tort. Synopsis: this presentation discusses the liability of the administration in contract and tort, with a focus on the relevant provisions of the Indian Constitution and the legal principles involved. It also provides a brief overview of the Crown Proceedings Act, 1947 in English law, and the Federal Tort Claims Act, 1946 in the United States. Finally, it mentions the government's liability in Tort Bill, 1967 in India. Key points. Contract. Article 299, 1, of the Indian Constitution requires that all contracts made on behalf of the government must be executed in the name of the President or Governor. If a contract is not executed in this manner, it is generally considered to be void. However, the government may still be liable for the benefits it receives under such a contract, on the basis of quantum meruit or quasi-contract. Tort. The government is vicariously liable for the tortious acts of its servants committed in the course of their employment. This principle is based on the legal doctrines of respondit superior and qui facit per alium facit per se. The government is also liable for its own tortious acts, such as negligence or nuisance. Comparison with English and U.S. law. England, the Crown Proceedings Act, 1947 abolished the common law immunity of the Crown from suit in tort. United States, the Federal Tort Claims Act, 1946 allows private individuals to sue the United States government for torts committed by its employees. Government's liability in Tort Bill, 1967. This bill was drafted to codify and reform the law on the government's liability in tort in India. However, the bill has not yet been passed into law. Conclusion: the government is liable for its contractual and tortious obligations in the same way as any other legal entity. However, there are some special rules and principles that apply to the government's liability, due to its unique position as a sovereign entity.